Think you can't infringe a patent if you didn't copy it? Think again. Welcome to Piggybacking on Existing IP, where we'll shatter some dangerous myths about patent infringement. In the next hour, we'll learn the critical difference between patentability searches and freedom to operate searches, discover why a granted patent might not protect you the way you think, and master the strategies that keep innovations legally safe while building on existing IP.
This is, I think, a really interesting topic. I actually overheard two patent attorneys in my office this morning talking about how clients often get confused between patentability searches and freedom to operate searches. So hopefully this tries to clear up some of the confusion or the mystification about some of these particular concepts. I should also say that I think the patent databases often contain a treasure trove of information, both for researchers and also for commercialization professionals as well. We'll look at exactly how you can search those databases and how you can extract that information. So in terms of what we're going to look at today, this builds on the webinar that Brooke Martin did about basic principles to IP. So we're going to start off with a refresher on patents and patent infringement. We're also going to talk about some myths about freedom to operate, or FTO. We're also going to discuss some of the differences between patentability searches and freedom to operate searches, and also cover reasons why researchers should search patents. And we'll also cover the individual steps in a freedom to operate search. So to start off with something that I think researchers know to be true, and that is that research builds on itself. Research doesn't exist in a vacuum. It builds on itself. It's more evolutionary rather than revolutionary, including greats like Isaac Newton and Rosalind Franklin. The research works by standing on the shoulders of the giants of those people who came before and did the previous research. What might be less intuitive is that innovation also builds on itself. So here's a quote from Henry Ford, which is very similar to Newton's quote. And that is that essentially he says that he didn't invent anything new, that he simply assembled the discoveries of other people into a car. And if we look at some of the patents that he filed, for example, on the Ford Model A, you can see that there is no overarching patent for the entire car. In fact, you've got patents on the individual components of the car, none of which Ford invented himself or with his team, but which he improved or developed for use with the motor vehicle. So, for example, he's applied for patents on spring suspension means. He's also applied for method patents on methods of constructing the automobile, in particular using assembly lines. He also applied for patents on non-glare lenses and lamps for cars, and as well as patents for the metallic wheels on the car. So a quick refresher from Brooke's presentation. A patent covers a new and non-obvious invention. So it protects the concept underlying an invention, and it protects it for up to 20 years, although in the case of pharmaceuticals, you can get 5 extra years due to regulatory delay. And so when we're talking about non-obviousness, we mean not obvious to a person skilled in that particular field. And so those are the two hurdles that you need to overcome in order to get a granted patent. So for freedom to operate is defined as the ability to use or commercialize a product or process without infringing another party's intellectual property rights, and in particular their patent rights. And that's what we're going to be talking about today. So jumping straight to patent infringement, a patent can have various claims. And so claims, for example, in a patent can be directed towards various features. So for example, you could have a patent claim with features that A, B, and C. And let's say there's also 2 additional features, feature D and feature E. So let's say that feature D is unrelated to A, B, or C, but feature E is an immaterial variant of C. And by immaterial variant, I mean, for example, if C talks about something being perpendicular or 90 degrees, E might be talking about it at being, for example, 80 degrees. So it's effectively doing the same thing, but it's an immaterial variant. So looking at what infringes a patent claim, integer A on itself won't infringe the claim because you need integers A, B, and C. And the same with A and B. But A, B, and C will infringe the claim, A, B, and C. A, B, and E might infringe the claim. So E was the immaterial variant of C. So by substituting E with C, there's a possibility of patent claim infringement. And of course, if you've got A, B, and E, and D, then the answer is the same as the above as well. So looking at what exactly is in a patent. So a patent, this is, I think, an example of the shortest patent that was filed at the US Patent Office. And I've included it because it fits nicely on the slide. But essentially, a patent is kind of like a research paper in that it is broken up into different sections. So it has a title, so in this case, metoprolol succinate. It has a technical field, which describes the broad area in which the invention relates. In this case, it's a pharmaceutical. A patent also describes the background to the invention. So it might talk about, for example, problems that exist in the prior art relating to the technology. And it might also have an object clause which says what the object is trying to be solved by the invention. The patent application will also have a description section where it describes the invention in enough detail so that a person skilled in the art can put the invention into practice. And finally, and very importantly, it has those claims that we just talked about. So the claims are a series of numbered paragraphs that appear at the end of the patent, basically set out the scope of protection that's being claimed by the patentee. So a patent really has a dual function. The description portion is describing the invention. The claims at the end are setting out the scope of the monopoly that's claimed by the patentee. So talking about some myths about freedom to operate. So one of the myths that you hear quite a lot is that you can't infringe someone else's patent if you have your own patent. And I can understand where that comes from, but because, for example, if you've got an Australian patent, you might be thinking, well, why would the Australian Intellectual Property Office grant me a patent for something that I can't use? Right? If I did start using it, I would be sued for infringement. But unfortunately, as we'll look at soon, that is a myth. Another myth is that a patentability search, for example, the searches that get carried out when you file a patent application by a patent office, will identify any patents that you might infringe. That's also a myth. Patentability searches and freedom to operate searches have completely different scope and completely different purpose. And the third myth that you often hear is that you can't infringe a patent if you didn't copy the infringement or you weren't aware of the patent. And I think this is due to confusion with copyright, because as Brooke said in her talk, for copyright infringement, you need to actually copy the invention. That's not the case for patents. So you can still infringe a patent if you didn't copy the invention, or even if you weren't aware of the patent. So where awareness comes in relevance is in terms of the damages that might get awarded. So you can be what's called an innocent infringer, which is where you might get told to stop or an injunction issued against you from stopping using the invention, but you might not have to pay damages because you weren't aware of the patent, but you'll still be asked to stop. So an example of a patented invention that could infringe another patent is this scenario here. So imagine that there are two patents. A first patent, patent A, gets filed and it describes in the description portion of the specification a cell which is transgenic for a particular gene, gene X. And it claims protection for a method of transforming a cell with gene X to get a threefold increase in protein Y. And that patent gets granted by the Intellectual Property Office. And then later, you've got another filing from a different company for patent B. Patent B describes a method of transforming a cell with gene X, as before, but also with gene Z to get a 10-fold increase in protein Y. Now, this patent will be granted by the Intellectual Property Office because it's patentable, because the invention is novel and inventive, but the patent does infringe patent A. So it is, as we looked at before in terms of the integers in a claim, it's covering the method of transforming a cell with gene X to get at least a threefold increase in protein Y, in this case, a 10-fold increase in protein Y. So can there be value in infringing a patent? Well, there can possibly. So if a third party wants to use the method of patent B, they'll need a license both from patentee A and patentee B. And patentee B will also need a license from patentee A to work the invention. So there are possibly cross-licensing opportunities there. This is a very recent example of where this can happen. This is a case in the UK at the moment, which is ongoing. They've had a hearing in July this year, and it relates to the University of Glasgow and one of its spin-outs, Deep Matter. What we know about this case, all that's happened at the moment is what we in New Zealand and Australia call an interlocutory hearing. So it's not the full hearing. So we know about what the facts are at the moment, or at least some of the facts. The University of Glasgow spun out a company called Deep Matter. As a result of that spin out, it transferred particular patents relating to digitization of chemistry. And these patents were referred to in the license agreement as the assigned technology. The lead researcher in Deep Matter decided to move back to the University of Glasgow. Later, that same researcher was involved in a second spin-out called Chemify. Chemify appear to be operating in the same sort of area, digitization of chemistry. And the University of Glasgow has allegedly licensed patents that were derived from the assigned technology that were assigned to Deep Matter to Chemify. And so the current litigation that's going on at the moment is that Deep Matter is wanting information from the University of Glasgow about, for example, things relating to freedom to operate, etc. This is an example where, in this case, Deep Matter is equivalent to patentee A in the previous example, and Chemify is equivalent to patentee B in the example before. If Chemify wants to work its inventions, if they are in fact derived from the patents that were assigned to Deep Matter, it's going to need a license from Deep Matter. And Deep Matter may have freedom to operate issues of its own in terms of it wants to expand into new technology if, as it alleges, its Chemify has been assigned patents that are derived off its technology. So a good analogy, and one that I've mentioned to clients before, is to think of a patent as if it's a sword and not a shield. And I once had a client who was a software developer, but during the weekends he was involved in medieval reenactments, and he said, "Thank you very much for using words and terminology that he could understand." But I didn't actually come up with this analogy, but it's a really good one. And I think it sort of helps to keep in mind the different roles that patents and freedom to operate play. So a bit like a sword, a granted patent can be used to threaten someone with patent infringement, or if you take it to court, to stop an infringer. But having a patent isn't a defense against infringement itself. As we looked at, you can still hold a patent, work the invention described in the patent, and still potentially infringe someone else's patent. But freedom to operate is like a shield. So a person who has freedom to operate, or FTO, can work their invention without infringing the patent rights of other people. Freedom to operate is produced usually by carrying out a search or an FTO search. We'll look at the process for doing that. But freedom to operate is not the same as freedom to patent. And we'll talk about the differences. So there's two types of searches, really. There's novelty searches or patentability searches, and there's freedom to operate or clearance searches. Novelty searches, the purpose is to find out whether the invention is patentable. So as we talked about, the two requirements to get a patent is the invention novel and non-obvious over what's already out there in the public domain? So novelty just means, has all the features of the invention been disclosed in a single document before? And inventive step is, if it is novel, would the invention be obvious over previous solutions? And inventive step is assessed from the perspective of a person skilled in the relevant field. Freedom to operate, the purpose is quite different. The purpose is, will any third-party rights be infringed by implementing the invention? And this is generally a much more time-consuming search because the search covers a wider subject matter. Any feature in an invention may result in an infringement, not just the novel features. So, for example, in the previous situation where you were claiming integers A, B, and C, if you've got D in your invention as well, but D is claimed by someone else's patent, then you could still have freedom to operate issues if someone has patented feature D, even if you're protecting features A, B, and C in your patent. And it's not always possible to assess the infringement risk at the time of search. And this is sometimes because patent applications or the claims can change as the application is passing through the Intellectual Property Office. So the final form of the claims might not be known at the time the search gets carried out. So looking at the different scopes of patentability and freedom to operate searches. So patentability searches, all of the documents in the world are effectively relevant. So any publication anywhere in the world could potentially be prior art. Whereas freedom to operate searches, they're narrower in that you're only looking at live patents or live applications. And that's because you're only concerned about whether you might infringe someone else's patent. You're not trying to see if the invention is novel over all subject matter of the world. When you are carrying out a patentability search, you're looking at the entire disclosure. So you're looking at that description portion, as well as the claims, as well as the abstract. Any part of that document which describes your invention could be relevant in terms of novelty and patentability. Whereas for freedom to operate, you're only looking at the scope of the claims themselves. So those numbered paragraphs right at the end of the patent. For patentability searches, there are no geographical limits. Effectively, anything in the world can be novelty destroying or be relevant as prior art. Whereas freedom to operate searches, they're carried out country by country. So when people talk about whether they've got freedom to operate on something, really what they're meaning is, do they have freedom to operate in a particular country or particular countries? There's no such thing as global freedom to operate. Patentability searches can be stopped or paused as soon as you find one document that is novelty destroying. So we had a case recently where our executive who was carrying out the search stopped the search after about half an hour because they found effectively a knockout hit, and we paused the search and went back to the client and said, this seems to be extremely relevant. Whereas for freedom to operate searches, you attempt to find all the documents in that particular country that could possibly be relevant in terms of an infringement risk. So there's quite, of those two searches, the freedom to operate search is definitely the bigger and more time consuming of the two. So what are the steps in a freedom to operate search? So the very first step is to identify all the aspects of the product or service that could potentially be the subject of a current valid patent. So anything which has only been in the public domain for the last 20, or in the case of pharmaceuticals, 25 years, the next stage is to identify the country or countries where your product will be made or sold. There's usually no point or purpose in carrying out freedom to operate in countries where you're not making or selling the invention. It can be useful to carry out your own preliminary searches for relevant patents, and we'll talk about how that can be worked in to the commercialization or the research process. But I would definitely recommend seeking advice from a patent attorney before making a commercial decision. The best approach is to work with a patent attorney on search strategy and to review the most relevant patents together. Patent claim interpretation is a bit of a dark art, and it can be very complicated. And I've got an example of a case where I was the junior counsel for the plaintiff in this case. And I think this is a great example of how, if you read a claim at first, you might get one interpretation, but when you read the words in the claim in light of the specification, you might get another interpretation. So this was for a extendable support leg for a side lifter. So side lifters, container trucks, which lift up containers from, for example, ports and put them on the back of the container. And because of the weight that's being lifted up, they need a support leg to support them. And in this case, I was acting for a Swedish company, Hammer Maskin, against their largest global competitor, Steelbro New Zealand. And the claim or the invention related to a support leg which could telescope out in order to get the support leg further out from the ground and therefore provide a bit more stability. And claim one included the words, quote, an extension part which is movably arranged in a bearing in the first support part. And infringement turned on the meaning of upbearing. Was it referring to a separate bearing between those two telescoping parts, or was it just referring to a bearing relationship between the two parts? And in the High Court, New Zealand High Court, we were unsuccessful. So the judge interpreted those words in a bearing as effectively referring to a noun or a physical bearing. But when we got to the Court of Appeal, the judges in the Court of Appeal looked at the description portion of the specification, appreciated that there was no physical bearing between those two parts, and therefore decided that those words meant bearing relationship rather than a separate bearing. So infringement did take place, or was found to take place in that case. So it just goes to show that first time when you read those words, you might think it refers to a separate physical integer, but it doesn't. So there's definitely worth referring patents and the interpretation of them to patent attorneys to get them to have a look at them, particularly where patents have been filed by competitors. So you'll be very familiar with the publishers of patents, journals like Nature or publications from IEEE. You might not be so familiar with the organisations who publish patents. In Australia and New Zealand, we've got IP Australia and the Intellectual Property Office of New Zealand, or IPONS. In the US, there's the United States Patent and Trademark Office, or the USPTO. In the UK, there's the Intellectual Property Office, or the IPO. There's also in terms of regional areas, there's the European Patent Office, or the EPO, which covers all the countries in Europe, including the UK. And there's also WIPO, or the World Intellectual Property Organization. There's no such thing as a worldwide patent, but WIPO, the UN body based in Geneva who administer the PCT, or Patent Corporation System, and they effectively streamline the process for applying for patent protection in lots of overseas countries. So freedom to operate is very much a country-specific search because not all patent applications are filed in all countries. So in 2022, there were about 3.5 million patent applications filed. So not patent applications in total, but just filed. And we can look at that table, and it's quite amazing that almost half of that 3.5 million patents filed in 2022 were filed in China. And the reason for that is that the Chinese government gives subsidies to people to file patent applications in China, although the government is planning next year to reduce the subsidies that are provided. So it'll be interesting to see whether these statistics continue into the future. But in terms of other large countries where there are a lot of patent filings, you see the United States, Japan, South Korea, European Patent Office. Australia is also in the top 10. So Australia is number 9. New Zealand is 26. In New Zealand, there are about 7,000 patent applications filed per year. In Australia, there are about 32,000. So between about 4 and 5 times as many patents filed in Australia as in New Zealand. And this affects freedom to operate because the more patents there are in a particular area, and we'll look at that later, the more searching has to be done, or the more patents that need to be looked at. As trans-Tasman patent attorneys, we can look at and draft and file patents in both New Zealand and Australia. So we're qualified to look at patents and prosecute patents in both jurisdictions. So what patent documents are published? Patent applications are usually published by an intellectual property office 18 months from the earliest filing date or the priority date. So if you come across a journal article that's just been published, you'll probably have to wait 18 months to see if the patent application was filed to protect its contents. And some database providers allow searching across multiple countries. Each of those intellectual property offices that we talked about, they'll have their own separate searchable register where you can search the patents filed within that particular country, and you'll be able to look at the current status of those patents or patent applications. But there are some providers that allow you conveniently to search across multiple countries. However, those different databases may have different coverage, and you want to be sure that if freedom to operate in a particular country is of importance to you, that you're using the right database. And another thing to note is there can also be errors in any database as well. So the names of some free or public databases for multiple country searching, and I've put these, they're probably listed in order of user friendliness. Google Patents has a search screen, which is like your traditional Google search engine. It's good for keyword searching. There are definite limitations with keyword searching. Some more sophisticated databases are eSpaceNet, which is run by the European Patent Office, and PatentScope, which is run by WIPO, which is the UN body that administers the Patent Corporation Treaty, or PCT system. So why should researchers search patents? I think there's 3 main reasons. The first reason is to keep up to date with what's happening. I think that's particularly in respect to industry developments. Researchers at universities, etc., will publish their work in publications, but a lot of people in industry will not. And therefore, if you want to know what industry is doing, the best place to find out that information is through patent searching and patent databases. The second reason is market intelligence. So, for example, when you're carrying out an invention disclosure review, you're probably familiar with using patent databases to search for whether the invention might be new and non-obvious. But you can also gain insights about the market, about particular problems that the market is facing from the database. And the third and I guess final reason is to verify whether you've got freedom to operate. So to assess the infringement risk. But over and above that, FTO results can also be useful to obtain funding or investment. So as we talked about, FTO is effectively a shield. So funding providers or investors are very much interested before they provide the funding or the investment, whether you do have freedom to operate in key jurisdictions. So we'll just talk about each of those 3 points separately. And the UK soldiers were marching through Washington, DC, and setting fire to all of the government buildings. When they came to the US Patent Office, they pointed their cannons outside the front of the building, and the superintendent of the US Patent Office came out, stood in front of the cannons with his arms outstretched, and said these words: "Are you Englishmen or only Goths and Vandals? This is the Patent Office, a depository of the ingenuity of the American nation in which the whole civilized world is interested. Would you destroy it? If so, fire away and let the charge pass through my body." It's quite a dramatic statement, but it worked. So every single government building in Washington, DC, including the White House, got burnt that night. The US Patent Office did not. I think that goes to show that people do respect the fact that patent offices do have this treasure trove of information in them. The second reason why you should be interested in carrying out searches of patent databases is market intelligence. As I said, you can work this into analysis of an invention disclosure to see if there's a particular market and also gain insights into what competitors might be doing before they actually release a product. This is an example of BMW's patents relating to turbocharging from all the way back from 1939 to 2011. And as you can see, there's definitely a marked increase. It probably increases from about 2000 onwards. And in 2011, November 2011, BMW introduced its first turbocharged M5 model. And I think in hindsight, anyone who was looking at the patents that BMW had been filing beforehand would have appreciated that that was a direction that BMW were heading in. You can't always be sure, looking at patent filings, whether a product is going to be released. Sometimes, for example, there are other reasons for a product not to be launched, but patents often give a good indication that something is about to happen. And as I said, FTO can also assist with funding or investment. So in Australia and New Zealand, there are both grants that specifically refer to freedom to operate. So in Australia, the Industry Growth Program grant talks about freedom to operate. In New Zealand, KiwiNet pre-seed funding and MB Smart Ideas both also ask whether you've got freedom to operate. And Horizon Europe, which both Australia and New Zealand are associate members of, you actually need to go one step further and actually provide a 2-page summary outlining your freedom to operate. So in terms of carrying out a freedom to operate search, what are the various parameters that you can use? So you can start off using names, so names of applicants or names of inventors. You can tailor your search by particular countries. You can also use keywords that appear in the specification or portions of the specification, for example, the claims. You can also use something called classification codes, which we'll talk about a bit later. You can use dates. So, for example, if you're doing an FTO search, you might limit your search to the last 25 years worth of patents. You can also search based on the status of the patents or patent applications. So for a freedom to operate search, it's not really necessary to look at abandoned or lapsed patents. You're more interested in ones that have been filed, under examination, or have been granted. So names and keywords are often of limited use when you're carrying out a freedom to operate search, and that's simply because they're limited by the language. If you are carrying out searches using names and keywords, I definitely recommend the use of wildcards. For example, question marks usually stand for one single character, and an asterisk stand in place for any number of characters. And that will allow you at least to do searches that might cover American versus British spellings or similar words. The other thing you can do is use alternative names for entities or features of the invention. For example, motorbike or motorcycle. Some features are difficult to use or describe simply because there's just so many different ways in the English language to describe something. You could describe something, two things which are being connected together as being connected or attached or joined or fastened or coupled, etc. So searching by using names and keywords is often of limited use, but it can be done. So say, for example, if your invention is a wetsuit made of polypropylene, you might have a lot of hits with just polymer, a lot less with polypropylene, but you can create a more targeted search by using keywords in combination. So you can also focus your searching on the part of the description or the specification that you're carrying out the search. So as I said, for friend to operate, you're really looking at the claims of the patent application rather than the description. The abstract is kind of like a shortish summary of the invention, but it's not necessarily the same as what's being described in the claim. So if you're carrying out a freedom to operate search, or you want to engage a patent attorney to carry out a freedom to operate search, it's really the claims that are the most important part. So classification codes are probably the most sophisticated way of carrying out a search. All patents that are filed at an intellectual property office are given a classification by a patent examiner, and they're classified into various areas of technology. And the two main patent classification systems in the world are the cooperative patent classification system, which was initially started by the US Patent Office and the EPO, but is progressively being used by other patent offices, and the International Patent Classification System, which is the one which existed before the CPC and is probably the standard around the world. So a classification code is an alphanumeric string that, in respect of the order and the numbers, relates to a particular subject matter. So, for example, A61P31/04 covers antibacterial agents. And as I said, because the codes are allocated by examiners and rather than by applicants, there can be mistakes. So it's worth, particularly for a freedom to operate search, to take that in consideration and to search broader than just, for example, the most relevant class. The system's also hierarchical. In the IPC, there are 8 main classes to start off with. In the CPC, there are 9, and they start off extremely broad. So as you can see there, A is human necessities, C is chemistry, G is physics, H is electricity, but they get progressively narrower and narrower. So, for example, I once had a paramedic come into the office, and he had an idea for an invention, which was a motorbike helmet with a built-in brake light. I think because he saw so many accidents relating to motorbikes being rear-ended by cars. And so he was thinking, oh, wouldn't it be great to have a motorbike helmet with a built-in brake light? And so looking at that, we can work out what the most relevant classification codes are. So human necessities is the broad class, and then A42 is headwear. And there are a series of, I guess, subclasses that come off that. So for example, A42B3/04 relates to parts, details, or accessories of helmets. And then A42B3/044 relates to lighting devices, e.g. helmets with lamps. But of all of those classes, the most relevant one for this invention is A42B3/0453, which relates to signaling devices, e.g. auxiliary brake or indicator lights. But as I said, for a freedom to operate search, if that was the invention, you'd want to go broader than that. So rather than just look at that particular class, you probably want to look at all the ones that relate to lighting devices on helmets to cover off, for example, mistakes that examiners have made in misclassifying something. Because although a helmet with a brake light definitely falls within the 0453 subclass, it also falls within the broader class of 0433, so detecting signaling or lighting devices on helmets. So a good approach when you're carrying out a freedom to operate search is to imagine it like a funnel. Start off broader and then narrow the scope of the search as you go. So say, for example, you're doing a search where in terms of the titles, there may be 30,000 results. But if you look at the abstract or the claims, you might get a bit narrower. And if you review the drawings and the description, even more narrower. And you might end up with a pile of the most relevant patents, and hopefully that's going to be a lot more manageable by doing a search, particularly using classification codes, but also using keywords or the combination of classification codes and keywords together to get a reasonable number of patents. So what can you expect at the end of a freedom to operate search? So there are various results. The first result that you could get is that there's nothing relevant at all. That always makes me a bit nervous as a patent attorney. And so if that is the case, I'd want to check the search strategy just to make sure that nothing relevant was being missed. The other result you get is that there are lots of patents, but none of them need a second look. That's obviously a great sign. You still want to monitor and update. As I said, claims can change during patent application process. So if you find something that looks, although it's not bang on, it might be relevant in the future and you want to monitor that patent or patent application, you can definitely do that. Another outcome is that there are a lot of patents and there are a few that need a second look. And so it's just a case of working through those patents and having a look at, in particular, the claims. And the other option, unfortunately, is that there might be lots of patents and they all need a second look. That's probably the worst case scenario, but that in itself might be a good thing in that that might be a deciding factor in terms of whether to continue with the project or not. So how do you deal with those problematic patents that come out as a result of a freedom to operate search? So the appropriate response depends on the individual country. So it's always worth getting a second opinion. As we looked at the sideloader case, even courts can initially misinterpret the claims in a patent or patent application. So definitely worth getting a second opinion. It's also worth finding the closest prior art. If you've got a patent which you think does cover your invention, try and find the closest prior art to that invention. Also monitor the progress of the patent or patent application and potentially challenge the validity of the patent or patent application as well, using, for example, the closest prior art. So you might be able to mount an argument that either the invention lacks novelty because it's been described in a single document, or if you combine two or more documents together that were published before the priority date of the patent application, that the invention would be obvious in light of those documents. Another thing to do is to watch out for divisional applications, and particularly in the US, what's called continuation or continuation in part applications. So even though the patent application that you're looking at, the claims for that seem fine, it might be that the applicant later on files a continuation or continuation in part application with different claims, and those claims could be problematic. It's always an option to wait until the patent expires, but of course, as we looked at, patents can last for 20 or 25 years, so that may or may not be an option. It could also be an option to design or work around a patent. I'll give an example where designing or working around a patent could have been done earlier rather than later. This is quite a famous example involving the manufacturers of BlackBerry. RIM introduced it in 1998, and NTP owned two US patents that were granted a couple of years earlier in 1995. NTP made no products. They existed purely to license the technology. Some people might call NTP a patent troll. Brooke talked about this in her talk. Patent trolls, organizations which own patents, but don't make a particular invention. So they look to license the technology that they've got rather than make products themselves. RAM settled with NTP and agreed to pay them quite a considerable amount of money to withdraw the infringement proceedings. Before they did so, RIM announced that it had developed a workaround which avoided infringement. There's a question there about whether RIM could have developed that workaround earlier rather than later. I don't know the ins and outs of how they launched the product, but the fact that they developed a workaround later suggests that it always was possible. So maybe they weren't aware of NTP's patents at the time they were developing the product. I think a better approach, and one that I think universities and research organizations can adopt, is to build freedom to operate into the research stage. So when you're carrying out a search to find out whether an invention might be new and non-obvious, you can also have a look at the claims at the back of those patents that you find. If the patents are still in force, work that into the development process, try and develop a product that's non-infringing right from the start, because there can be innovation involved in design arounds or workarounds to get around the wording of a patent or patent application. I would definitely get advice on the interpretation of patents from patent attorneys. Patent interpretation can be a dark art, and the wording can not be as intuitive or as literal as you think it might be. If the product or the reworked or redesigned product doesn't infringe any patents, then you're free to proceed to market. If it's new and non-obvious, you can also obtain your own patent protection for it as well. So I think we're almost time for questions. But also I think next Thursday, you've got Anna talking about contracts as well, which I think builds off a lot of the work that we've been talking about as well.
Perfect. Okay, it's time for Q&A. There is one question from Amy. If a patent exists that would decline your FTO but expires soon, example 2 years' time, can you develop a product during those 2 years as long as you don't sell the product until after the patent lapses?
It's a good question. I think what you're getting at, Amy, is research exemptions in patent legislation. So it depends on the individual country and what the wording of those research exemptions are. Often they relate to you're allowed to work out how a patented invention works without infringing a patent, but commercial applications of an invention are usually fall foul of those research exemptions. So it very much depends upon the individual country and the individual law in that country. But yes, you can, in a lot of countries, including Australia and New Zealand, work out how a patented invention works, but commercial exploitation of it would have to be held off until the patent is expired.
Brilliant. And another question from Ian. Grace periods between publication and ability to file application to systems?
So I guess grace periods can be useful, but I guess grace periods almost sort of a last resort. They're a bit like research exemptions. The law differs in each country about grace periods. So a lot of countries, including Europe, China, don't have any grace periods. But other countries like the United States, Australia, New Zealand, we do have a 12-month grace period for disclosures that are made either by the applicant or with the applicant's consent. It is definitely possible to make use of grace periods for filing a patent application, but you will limit the countries that you can file in by doing that. So the best course of action is always to file a patent application first before you publish, and then publish second. Patent search to see whether someone's protected what's described in the journal article, because you can count back 18 months. So when it gets published, 18 months after the journal has been published, to see whether someone's protected the invention or not.
Right. Are there any other questions? Just while we wait, the poll has been launched. It's only 3 questions. It only takes 20 seconds or so. So it'd be great if everyone could do that. Any more questions? You don't have to type them in the chat now. You can just raise your hand and ask them.
And also, I'm happy to answer any questions that anyone might have offline as well. Got my contact details up there, so definitely do reach out to me if you've got any questions. Being a trans-Tasman patent attorney, we are familiar with the law and the procedure both in Australia and New Zealand. So yeah, we definitely act for clients in both countries. And for us, whether you're in Australia or New Zealand, you're effectively a local client.
Are there any final questions? Doesn't look like anybody has their hand up. Seems like you've answered all the questions in your webinar, Adrian.
Oh, that's good because, as I said, I think there's a lot of myths and misunderstandings about freedom to operate. So I'm pleased, at least I hope it did clarify some things because, yeah, I think this is sort of a confusing area for a lot of people. I think there's a lot more attention focused on obtaining granted patents and using patent databases to find out whether the invention is new and non-obvious, but not much attention is focused on freedom to operate and gaining market insights or market intelligence from patent databases as well. So yeah, I'm pleased that hopefully I've been able to clarify some things there.
Definitely has. This was such an insightful and interesting webinar. Thank you, Adrian.